Lordship may kindly peruse the order dated 3/4/24. Lordship had directed me to go through the lower court record as to find out as to why only one witness was examined. Lordship, perusing the court records, a very strange and unusual thing has come to my notice. Lordship, there has been alterations in the records of the learned court below.
No,
Lordship,
that is not the subject matter before this court.
Lordship, but I need to point that out, Lordship, because there has, which is relating to the issuance of summon, Lordship. Lordship, I had obtained certified copies prior to the filing of the bail application. And Lordship, the record which has been received by the Honorable Court, there are alterations, Lordship, in the same very order. Lordship, may I kindly have a look at the learned trial court's order, Lordship, dated 24/1.
Dated?
24/1, Lordship. The trial court's record, LCR record, Lordship.
Yes.
Lordship, the fifth line. Special PP NCB to take steps on witnesses, upon witnesses. Lordship, got it? Lordship, may come to my bail application, Lordship, page 116. Lordship, this is the certified copy that I obtained prior to filing of the bail application. This specific line, Lordship, is missing from this in this order. Lordship, the order was passed on 24/1. I had obtained the certified copies on 29/1. There was 5 days of Lordship difference. This smacks of malafide, Lordship. I don't know who did it or what was the intentions behind that. I have no idea, Lordship. But it smacks a lot of malafide, Lordship.
What malafide?
Lordship, because they're taking summons after the order has been passed and after the bail application has been filed.
No, even this line is added here.
Lordship.
So what malafide can be attributed to the court below?
Lordship, after the bail application has been filed, probably they're taking steps. Lordship, I don't know. I'm not even, Lordship, aware of that. But the mere fact that it's not there, this line is not there, Lordship, prior to the filing of the bail application.
Yes, Mr. Kyle. Pardon? Yes.
So then Register Vigilance may be directed to make inquiry how this happened. Who has manipulated or who has edited on this words?
No, this will not serve our purpose.
That's it.
This will not serve our purpose.
Which one, Lordship? As an officer of the court, Lordship, I had to point this out, Lordship, that there are certain anomalies in the record, in both the records. Lordship, notwithstanding, Lordship had asked me to prepare a date of the list of dates on which the case was listed and why
Hmm.
the witness could be examined. Lordship prepared a chart.
Lordship, even then, Lordship, some question has been raised. And some manipulation is, as per my learned friend's submission, something has been, I can say, which manipulated or something has been added.
Hmm.
So Lordship, it is required to be, extra vigilance may be make inquiry.
Lordship, the list of dates that I've given Lordship in NDPS case 47, Lordship will kindly observe that on 3/6, 17/6, 17/10, 31/10, 6/2, no steps were taken in spite of orders by the learned court below to take steps.
Hmm.
Lordship, another submission I want to make is Lordship, although the summons are issued, but Lordship, there is no SR returned as to whether the summons are executed or not. And Lordship, even after the summons are issued, if the witnesses are not appearing, in case any coercive action is taken to compel their appearance, Lordship, there is no indication in the lower court record. Lordship, a similar situation
No,
that I
to
wrote.
take a coercive step, there must be service of notice.
Exactly, Lordship. So there is nothing as such is submitted before the learned trial court. Lordship, a similar situation that arose before a coordinate bench of this High Court.
Hmm.
Lordship may kindly have a look at.
Hmm.
Lordship may kindly come to para 5. Lordship has it.
Hmm. Yes.
Lordship, accordingly, the learned trial court has submitted its fresh report along with additional depositions of prosecution witness. The fresh report reads as hereunder. Lordship, the report, the second paragraph, Lordship.
Hmm.
It is to be mentioned herein that after issuance of summons to the witnesses by the office of this court, most of the times NCB collects those summons to serve the witnesses, and no service reports thereof are submitted by NCB to this court, except one summons returned after service on 18/11/21 by Dispur Police Station. Thereafter, Lordship may kindly come to this. Is Lordship, after that, the learned trial court below has given the report. And Lordship, the observation of the Honorable Court is there in paragraph 7, Lordship. On bare perusal of the case record along with the above report, it transpires that after the charges under section 22C and 29 of the NDPS Act were framed against the accused petitioner and two others on 9/11/2020 for illegally possessing 1.992 kilos of methamphetamine tablets, which amounted to commercial quantity under the Act. Lordship, the summons issued to the prosecution witnesses were not regularly served by the NCP, nor service reports were submitted to the learned trial court below by the NCP. The summons were issued by the court for service by the NCP. The laxity in service of the court process on the witnesses and disruption caused by the COVID-19 pandemic resulted in ordinate delay in disposal of the case. Lordship, thereafter, because of this very reason, Lordship, this honorable coordinate bench went on to granting bail, Lordship. Lordship, same thing is happening in this case.
Yes, Mr. Kayal.
Lordship, there are two cases of the same petition, cases are different, Lordship.
Hmm.
One is 47/29 and another is 49 of 22. See, in one case, LCR has been cut in 47.
Both the cases.
Hmm.
My learned friend has submitted chart, Lordship. It's been 47. And probably my learned friend is submitted judgment of this Honorable Court in coordinate bench. But if my first submission, there cannot be any parity in case of bail application also. And secondly, delay in trial, as recently held by the Honorable Supreme Court and this Honorable Court also, there is a judgment that delay cannot be a ground for granting bail to the accused person. So when there is a serious heinous crime is there. And Article 21 is also will not come into play. And recently, Lordship, in case of Sarvinda Prasad until Honorable Supreme Court says that 436 capital A will be applicable in case of NDPS, where the maximum punishment has to be calculated. Here, Lordship, maximum punishment is 20 years. And in this case, Lordship, the accused was arrested on in 57. He was arrested on 5/9/2021.
Lordship, 25 or 21 is when I was arrested.
47.
Both the cases were arrested together.
So they were arrested on 5/9/21.
25/9/21.
5/9/29. 21.
So in this case, this BA number 427,
47.
427, how many witnesses have been cited?
Only 4 Lord.
Lordship, only one has been examined so far in 427. Out of 8, only one has been examined and discharged, and the another witness has appeared. He has been examined. Cross examination is reserved due to paucity of time.
No, total how many witnesses examined?
One examined, cross-examined and discharged. One prosecution witness is examined, but his cross-examination was reserved for paucity of time.
Lordship, the not submitted by learned friend, page 5, serial number 18.
Page number?
Page number 5 of not
That's what I'm
submitted by my learned friend. Lordship.
That's what I'm saying. that
Serial
one has
number
been
18.
examined.
Serial number 18.
Yes.
1/4/2000.
No, we are now for NDPS case number 47, yes.
Yeah, 47.
So one has been examined, Lordship, one examined, cross-examined and discharged, and one witness has been examined and his cross-examination has been reserved for due to paucity of time. That is on 1 April 24.
Mm.
And regarding Lordship, the judgment that I've just referred to, I'm not seeing the bail on the ground of parity. Lordship, I'm just trying to emphasize the procedural lapses which is there by the NCB in the trial courts below, based on which this court has granted the bail. It is the ratio, Lordship, I'm relying on, and not the parity, Lordship, that I'm seeking. Lordship, there are other cases which I'll be also be relying on, Lordship. For delay, Lordship, the section embargo of section 37 will not be attracted. Especially, Lordship, when the delay can be attributed to their fault. Lordship, I've made a compilation of judgments that I'll be relying on. Lordship, just one specific judgment I want to, Lordship, one specific judgment I want to place my emphasis on. Lordship, on page 37, Lordship. Delivered by the Honorable Delhi High Court, very recently, Lordship. On 28th of February 24.
Yes,
Lordship may kindly come to page 54 for the delay part.
page number
54, Lordship. Para 42. May I read, Lordship?
Hmm.
Very good. Secondly, the applicants have been in custody since 13/12/2020. The learned trial court in its order dated 6/6/23, while rejecting the application of the applicants for being released on bail, has itself recorded the trial is at a nascent stage and the witnesses are yet to be examined and the evidences are yet to be proved. Thereafter, Lordship, the Honorable Court discusses the case of Ravi Prakash, Mohammed Muslim, and Lordship some other judgments, and thereafter Lordship comes to the conclusion at para 49, page 61, Lordship. Lordship has it. From the above, it is apparent that in spite of the stringent test to be made by the accused under section 37 of the NDPS for being released on bail, it has been held that the same does not fit a grant of bail to the accused on the ground of undue delay in completion of trial. It has been held that prolonged incarnation generally militates against the right to life and liberty guaranteed under Article 21 of the Constitution of India, and therefore the conditional liberty must override the statutory embargo under section 37 of the NDPS Act. Lordship, is the very latest judgment delivered in February of 2024. Lordship, this judgment has taken into account Ravi Prakash, Mohammed Muslim, and several other 2-3 judgments Lordship are well aware of the Honorable Supreme Court. Lordship, will place my reliance on another judgment, Lordship, very similar to our case, which your Lordship has delivered. Lordship, on page 170 of my compilation, Lordship. Lal Badshah Bania, Lordship. Lordship, may kindly come to para 3 of the judgment, page 171. Lordship, the case is exactly similar to ours. No contraband has been recovered from our possession. It is only on the confession statement of the other co-accused that I have been arrested. May I read your Lordship?
not necessary.
Lordship, even this is for the second bail application, and Lordship, in this case, 13 witnesses were examined out of 19. In the Lal Badshah case, Lordship. I'm sorry, Lordship. Out of 23 witnesses, 13 were examined. Lordship, and more importantly, the dictum of Ravi Prakash has not yet been overridden, wherein it has been held that in case of delay in trial, Lordship, the
No,
Article
that's all
21.
right, but delay has to be seen.
Lordship,
Who is
Lord-
responsible
Lordship,
for the delay?
Lordship.
Why delay occurred?
Lordship. So Lordship praises the chart that I've given Lordship. Lordship, on several dates, they failed to even take steps, Lordship. And after that, Lordship, even after issuance of summons, whether that is being served upon the witnesses or not. Lordship, that is why I was referring to the judgment of this coordinate bench, Lordship. Because SRs are not being given to the learned trial court below. So trial court is not even aware as to whether they're taking summons or not. I mean, they're executing the summons or not. Lordship, 3/6, 17/6, 17/10, 31/10, 6/2.
Yes, Mr.
Lordship.
Kyle?
Lordship, with regard to Ravi Prakash and Mohammed Muslim,
Hmm.
Lordship is reason to consider all the judgment in this application. Biju Prakash. Biju Prakash. Condition bail application. Application. Private.
23.
So I've written the paragraphs on the top of the judgment. The judgment, the paragraphs I've written in the top of the judgment given to you. And this is a Supreme Court judgment, Lordship, paragraph 16, 17, 18, 19, 20. It's a full bench judgment. Right to SCC. 2005, to SCC.
No, Mr. Kyle, this is all right. But this present application is a file on the ground of delay.
Yes, Lordship.
Delay on account of summoning the witnesses and also for not taking any step in issuing process to the witnesses.
So that Lordship,
Hmm.
law court record reveal what is their Lordship. I cannot
Hmm.
make any submission on that.
Hmm.
But with regard to, because this is a heinous crime where trafficking of commercial quantity is involved and is held by the Honorable Supreme Court in different judgments. In latest case, Lordship Gurvinder Singh, Lordship has considered this aspect of the matter in Swan Singh. in bail application 4458/23 that even mere delay in trial in case of heinous crime cannot be a ground for releasing the petition on bail.
Lordship, I want to make a distinction before this 453821.
Let him complete.
Lordship.
So I have submitted 3 judgments.
Hmm.
One of Supreme Court is a full court judgment, Lordship,
Hmm.
that 2005 to SCC page 42, paragraph 18, 19, 20. One of the Supreme Court says in case of non-bailable offense, there cannot be any question of violation of Article 21 laws. And because he is behind the bar in process of the judicial process, Lordship, not at the whims of the president or the court, Lordship.
Hmm.
And secondly, Lordship, I have submitted 2 judgments passed by your Lordship, where Lordship has considered Nawaz Khan's case, where position, one submission is made by that nothing was recovered from the position of the petitioner, because petitioner was present on the spot. And Nawaz Khan, Lordship, Honorable Supreme Court considered this aspect of the matter also. And 2 judgments also, Lordship, all the judgments referred by my learned friend as considered by your Lordship, while rejecting the bill application of different accused, Lordship. Even then, Lordship, in some cases, the trial was continuing for more than 3 years in others. And we applies under Lordship, we applies section 436 capital A. In this case also, Lordship, the maximum punishment is to be calculated for deciding the bill application. This is my humble submission, Lordship. LCR before your Lordship, Lordship considered.
Lordship, my submission would be, Lordship, I am not on the ground that there is only delay. Lordship, but that there has been delay which cannot be attributed to me, Lordship. And Lordship, this fact that if there is a delay owing to the prosecution's fault, then my fundamental right under Article 21 will prevail over Section 37. Lordship is there in Ravi Prakash, Lordship Mohammed Muslim, Lordship Biswajit Singh, Lordship Dheeraj Kumar. Lordship knows this case was very well. Lordship, even a coordinated bench of the High Court, Lordship in Sanjay Shah, Lordship page 161. Lordship has taken into account all these case laws and has Lordship come to the conclusion that yes, Article 21 will prevail when there is a delay in trial. And Lordship, I just want to emphasize on one more point, Lordship, that the delay, the Lordship, the judgment of this Honorable Court, Lordship judgment, Lordship, in that case, there was a delay in trial because the presiding officer was absent. But Lordship, here, the faults can be attributed to the prosecution, Lordship. On Lordship, 5 days, they have not even issued summon, Lordship. They failed to even take steps for issuance of summon, Lordship.
No, on some occasion, the court was also
Lordship,
remain
Lordship,
vacant.
definitely, that is true, Lordship. But Lordship, again, but that having said that, Lordship, 5 days, Lordship, they have even failed to take steps. And Lordship, no fault can be attributed to me that either prosecution witness was not cross-examined. There is no fault that can be attributed to me, Lordship.
Okay, we'll see. Heard Mr. S. Mitra, learned counsel for the accused, and also heard Mr. S. Sekaya, learned standing counsel for the NCB. Argument concluded, order reserved.
Lordship, another judgment, recent judgment of the Honorable Supreme Court in the case of that 6 months of the state can be vacated by within 6 months. In that case, Lordship, paragraph 27 to 31 are important to be that Allahabad High Court Bar Association versus constitutional bench judgment, Lordship, where SCR surfacing judgment was revisited. And during that, Lordship, the court has also considered, please to consider the load on the trial courts and how that whether any direction can be issued to the learned trial court for completing the trial within a specified period. All these aspects has been considered. Particularly paragraph 27 to 31. These are the important to be taken into consideration.
How this is important?
Because Lordship, here the trial, because in that case, Lordship, the question of law was referred to the full bench, that whether that in SCR surfacing, Honorable Supreme Court is directed that if a stay order is there, that will be automatically vacated within 6 months. That was revisited, and while revisiting, Lordship, the Honorable Supreme Court had also come to a conclusion whether any direction can be given to the trial court and why the cases are being delayed. All these points have been considered in paragraph 27 to 31.
This heir unto lay is also referred.
Yeah, all judgments has been taken into consideration. And Lordship, paragraph 31, Lordship, may please to see the Honorable Supreme Court has come to conclusion what is the load on the trial court. Why trials are being there cannot be any single ground for delaying the trial.
Lordship, irrespective of whether there is a direction from this High Court or not, Lordship, the trial courts, if the trial is, Lordship, I'm not on the ground that trial has to be complete within a certain period of time. Lordship, I'm only on the ground where the Honorable Supreme Court has also held is that, Lordship, bail is to be granted. My liberty under Article 21 will prevail in case there is a delay and which can be attributed not to the courts but to the prosecution, Lordship. That is my submission, Lordship.
Okay.
Much appreciated.
Obliged, Lordship.
Sure.
9 same. Lordship.
Within 9 cents.
Lordship,
Okay.
custodial period kindly be noted. The custodial period.
Pardon?
The custodial period, Lordship, may kindly note. How long I've been behind the bars?
Yes.
Lordship,
In
928
item
days.
number 8,
Both are same, Lordship.
same.
Same, Lordship.
Oh, how many days?
928 days. 2 years, 6 months, 18 days.
Okay.
Lordship. Obliged, Lordship.
Right. Material.
Item number 22 upgraded. 22 upgrade.
Visual worship. Is there yes, there worship perhaps.
Yes, Mr. Borwa.
My learned friend has gone for receipt, my lord, he is in legs
Where?
in court number receipt 16.
Hmm.
Sorry, I'm sorry, court number 13 receipt. So let him come receipt. He has gone to the case there.
Hmm.
We have to put it there. Well, he has come.
So, my lord, I have another report, my
Hmm.
item number 22, my lord. Here, my lord, we have received the case there, my lord.
Hmm.
From the case there, it reveals that I has collected sufficient material, my lord. All the witnesses said, my lord, his involvement, my lord. IT Ravidas, my lord. And those witnesses also examined who has parcelled the land from the present petitioner, my lord.
Hmm.
That witnesses are also available in the case there, my lord. And here, my lord, main victim, his statement, my lord. Rontu Soikia, my lord.
Hmm.
And it was parcels, it was taken money, but thereafter it was sold to the different person money. Without repaying the full amount of money.
No, he may be involved in other cases, but whether he is involved in the present case.
My lord, that is,
Hmm?
from the, my lord, from the statement of the complainant also present petitioner, my lord,
Hmm.
his name is there, my lord. From the.
No, in the FIR also his name is there,
Right.
but it is stated that Bhaiti Ravi Dase বহু মাটিৰ ধন দালালি কৰি কেইবা বছৰেও চুচৰাই
My lord,
মোৰ হাতত তথ্য আছে।
and he is the relative of the, my lord, victim, my lord.
Hmm.
It was also reflected in FIR also, my lord.
Hmm?
It was reflected.
This is an omnibus statement against the present applicant in the FIR.
My lord.
But, is there any material in the case area? So what is your case, madam?
I'm not in a condition to speak very much.
Hmm.
Lordship, in this case, your main accused already been released, your lordship. He is just for some a few lordship, last portion also he is involved, your lordship.
Hmm.
But the main accused person got released, lordship, that is Pankaj Hukam, Papaporita, Rachel Hindi, already been released on bail, your lordship.
What is the orders?
So, there you lordship. But this one.
And that is one ground, and the other grounds? What are the other grounds?
In this case, your lordship, if you produce the lordship FIR, your lordship. He cannot be involved in this case, your lordship. The even complainant itself saying that thing, your lordship.
No, bail to the other accused
That
were granted due to non-compliance of this 41A. Hmm? This is AB.
AB, my lord, these are BA, my lord.
This is AB.
I will abide by every condition, your lordship.
Pardon?
I will abide by every condition, lordship. This honorable court release me on bail, your lordship. Because this is a matter where lordship 41 notice can be lordship issued, your lordship. Ratendra Kumar until it was also reflected in this case, your lordship.
Oh, Mr. Sharma, whether this person,
My lord.
IT Ravi Das and this Durga Ravi Das is the same person.
Durga Ravidas.
No, lordship.
In the FIR itself, my lord, IT Ravidas broker, my lord, thereafter Durga Ravidas,
Hmm?
my lord.
Where it is mentioned.
In the FIR, my lord,
Hmm.
in the first para, my lord, the second para, last part. Also, IT Ravidas broke a lot of money in several years. I have also documents, my lord. Thereafter, next para,
Hmm.
along with Durga Ravidas. Then it will be clear for you.
Violable question, it was subsequent.
No, present application is filed by IT Ravi Das.
IT Ravidas, my lord.
So
Here is
they are
the-
different person.
Here is the my lord, last portion, my lord, in the particular, my lord.
Hmm.
লগতে ভাইটি ৰবি দাসক বহু মাটিৰ ধন দালালি কৰি কেইবাবছৰ চোচৰাই মোৰ হাতত তথ্য আছে। That is page number minus 9.
Hmm.
In the next
Not
page.
in this case, your lordship.
লগতে সৰু বগীয়া ৰন্তু শইকীয়া নামৰ ব্যক্তিজনৰ পৰা 21 চনতে গৰু বন্ধাৰ নিবাসী দুৰ্গা ৰবি দাসে
Hmm.
6 কথা মাটি বিক্ৰী লম বুলি
No, the witness if I have referred to in the case that he He deposed against this Bhaiti Ravidas. No, this Durga Ravidas.
My lord, then I will have to clarify, my lord, whether same person or not, my lord.
Not simple. FIR itself speaks lordship.
Here is the informant also two, my lord, Jitumoni Bora and Rontu Sokia, my lord.
Hmm.
The power ownership is 5 acres.
Jitumoni Bora and Rontu Sokia.
So the allegations are basically against Durga Ravidas. Heard Ms. G. Bora, learned counsel for the applicant, and also heard Mr. B. Sharma, learned additional PP for the state respondent. This application under section 438 service is prepared by applicant Bhaiti Ravidas, who has been apprehending arrest in connection with Jafalamanda PS case number 17 of 2024 under section 120B 420 406 384 506 34 IPC for grant of previous bail. Is to be admitted here that a noted case has been registered on the basis of one FIR lodged by one Jitu Mani Bora or Jitu Mani Bora and Rontu Soikia.
Right.
No, one Rontu Soikia and Jitu Mani Bora on 27/2/2024. The essence of allegation made in the FIR dated so and so is that one Pankaj Phukon, Papu Kolita and Bipul Handi have purchased a plot of land belonging to Rontu Hoikia. Belonging to Srimati Onima Hoikia, wife of Rontu Hoikia. And they have not been paying the price of the same and dragging the matter for years together. And accused Papu Kolita and Bipul Hendik have taken a sum of rupees 90,000 as brokerage from him. And one Bhaiti Ravi Das also involved in the brokerage, involved in the sale and purchase of land. And he also addressed the owners of the land without paying money, without paying price of the land. And one Durga Ravi Das also purchased a plot of land measuring 6 katha in the year 2021 from Rontu Hoikia. And he has not been paying any price of the same. Ms. Bora, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR, and that some of the co-accused who have already been arrested here in this case have already been granted bail by this court by order dated 7/3/2024 and in BA number 670 of 2024, and that he is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. Whereas Mr. Arjabor or Mr. B. Sharma, learned additional PP, has produced a case before this court and submits that the IO has collected some materials in support of the allegation made in the FIR, and therefore Mr. Sharma has opposed the petition. Having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on the record and also perused the case diary with the assistance of Mr. Sharma, learned additional PP. The case diary indicates that The allegations are basically against one Pankaj Phukan, Dipul Hendik and Papu Kolita. Though some accusation has been made against the present applicant, for involving in the sale and purchase of the land. And in view of the materials collected so far in the case diary against the present applicant, as well as the stage of investigation, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with case number so and so under section so and so, he shall be released on pay bail on his executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of Aziz M. Collier without prior permission. Case there will be returned.
Okay.
Issue number 30, bail hearing.
Wait, please, Your Honor. 439 application, my lord. It's a charge sheeted case, my lord. So under POXO, my lord. Here, my lord, charges were also framed, my lord. Under section, my lord, 366A and 4 of the POXO, my lord.
Whether notice was served,
A notice was served, my lord, and I have filed an affidavit that I have served the notice, my lord. That affidavit is in record. Affidavit, my lord.
but how you have caused service of notice?
My lord, through the police, my lord. Through the police, my lord.
Where is the affidavit?
My lord, that affidavit, my lord, I filed, my lord, it's on the record.
Pardon?
It's in the record, man. You can start from page 33, my lord.
F. Okay.
December.
Page 39, my lord. The
heard Mr. NJ Dotto, learned counsel for the accused, and also heard Mr. RJ Barua, learned additional PP for the state respondent. None appears for the respondent number 2. Though notice upon the respondent number 2 was served to the officer in charge Romia Police Station on 19/12/2023. In view of the notification issued by the registry of this court dated, what is that notification? So we will engage on a legal aid counsel or amicus curiae to represent the respondent number 2. So one notification has been issued very
Yes,
recently.
I have gone through it, one legal.
So the victim as the informant has the participatory right. So in spite of service of notice, he failed to turn up. So we will engage on legal aid counsel. So the list. Borra, suggest one name.
We tried to have a lady,
Lady.
lady, because POXO is there, but
Who can be?
I have not gone through the list.
Regular হয় না Nazia Hassan. Nazia Hassan. Is she regular?
I have not seen her.
And
last
Hassan.
3 days.
Meghali woman overloaded, no?
Priyanki Das is there. She
Hmm?
comes.
He does.
Priyanki Das.
He does. Okay. Miss
As amicus curiae.
P does be appointed as amicus curiae to represent the case of the respondent number 2. Rest shall reflect the name of the respondent, name of Miss MSP does in the cause list and furnish the copy of the petition and other relevant documents well in advance before the next date. List the matter on 18 or 19?
19.
19. 19.
32.
I have applied.
Maybe taken after some time, my senior was
Pardon?
32 may be taken after some time. In the case matter is.
33.
First time the second of all.
Yeah, it is. Next. Next.
Yesterday, my lord, matter has come up, lordship. So since the matter case that was not updated, lordship, since last December 2023, lordship. So I have contacted him, my lord, investigating officer, lordship, and I have asked him that, my lord, if this person is, my lord, required for further investigation, lordship. He said that, lordship, as far as this person is concerned, he has, my lord, completed his investigation, lordship. So further details may not be required.
Not required.
Not required. That is the verbal minor instruction I have received from the IOD. Council officer.
You have received the case, Daddy.
Yes, case diary we have received, lordship, but it is not updated since December 2023. Last update is my lord 22nd December 2020.
So he is languishing in jail as for how many days?
30 days today, as on
30
today,
days.
30 days, Lordship.
30 days.
He was arrested on 10th of March 2020.
কবে? এই, এটা হলো বন্ধ করে দিলে ভালো হয়, ভালো। So this is Cyber PS case number 12.
Lordship.
My lord. I have informed me, my lord, that my lord, he can take back that case there, and he will be able to submit my lord after vacation also. So that is why I have asked him whether this person's, my lord, further interrogation is required or not.
Heard Mr. your good name?
PK Basu.
PK Basu, Lord Counsel for the accused, and also heard Mr. Arjay Barwa, learned additional BP for the state respondent. This application under section 439 CRPC is referred by accused Samsul Haq, who has been languishing in jail Hazot in connection with Cyber PS case number 12 of 2023 under section 120B 419 420 IPC read with section 66C 66D IT Act. Edit section 409 468 471 IPC. This to be noted here that above noted case has been registered on the basis of an FIR lodged by one Apu Gogoi, Circle Officer, Dispur Revenue Circle on 2/11/2023. The essence of allegation made in the FIR dated so and so is that it has come to his notice that a mutation order was passed online in Dorothy portal on 5/10/2023 in case number MET stroke DIS stroke 2022-23 stroke 96042 stroke OMUT against a date bearing SL number 4260 dated 31/12/1996, wherein no offline record of and also the record of issuing any notice or order so passed was found to be available in his office. And from 1/10/2023 to so this FIR is not complete, no? What is the date in second paragraph, third paragraph?
Lordship.
The login history
Yes, Lordship.
from 1/10/2023 to what is the date? Next
26,
date.
26/10/2023.
26/10/2023.
Yes, Lordship.
There was a login history of login stroke logout history of 52 times for from 4/10/2023 to 26/10/2023 with an IP address number 10.177.88.65 and 2 times on 10/10/2023 in IP address number 10.177.88.58. And the above IP address and the said IP addresses were not from the official list of the 33 operational IP addresses of his office. And the aforesaid two IP addresses are unauthorized and illegal. The learned counsel for the accused submits that the accused was arrested on 10/3/2024, and since then he has been languishing in jail for last 30 days. And that some of the co-accused have already been granted bail by this court. And that the present accused is ready to cooperate with the investigating agency. And therefore it is contented to allow the petition. Whereas Mr. R.J. Borua, learned additional PP, has produced the case study before this court and submits that the same has not been updated since
22/12/2023.
22/12/2023.
I'm sorry, Lordship, 16/12, Lordship. 16/12.
16/12. 16/12/2023. And as such, the present accused was arrested on 10/3/2023, and as such, no materials against the present applicant is available in the case diary. However, as per verbal instruction, the further custodial detention of the accused is not warranted here in this case. But having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It appears that the case diary has not been updated since so and so. And as such, no materials against the present applicant is available in the case diary. However, it appears that he was arrested on 10/3/2024, and since then he has been languishing in jail for last 30 days. In view of the period of detention, and also in view of the fact that some of the co-accused have already been granted bail by this court after perusing the case diary, this court is, and also in view of the submission of learned additional PP, this court is inclined to allow this petition, and accordingly it is provided that on furnishing a bond of rupees 50,000 with 1 surety of like amount to the satisfaction of the learned Chief Judicial Magistrate Kamrup M, the accused be enlarged on bail.
Number 10,
Case diary will return.
is an action.
I remember 10 lordship, this accused person, he is on interim lordship, and he has also appeared pursuant to the interim direction of this honorable court lordship. But my lord, medical report was called for by this honorable court, that has not been received lordship. He has been named in the FIR.
Mr. Arjay Barua, learned additional PP submits that he has received a case diary, but the injury report of the victim is not available in the case diary. And prays for granting him some more time. Here is accordingly allowed. Rest is the matter on
26-4.
26. Till an interim order pass earlier shall continue.
Item number 11. Item 11.
None appears for the applicant on call. Rest shall list the matter after 1 week.
Item 12.
None appears for the applicant on call. Rest shall list the matter after 1 week.
Item 13.
Same.
Item 15.
So you are on interim.
Yes, your lordship, on interim.
Have you appeared before the IO?
In respect of respondent number of petitioner number 1 to 4, I have appeared. One of the petitioner did not appear, your lordship. Due to some.
Why?
Actually, this case pertains to a family dispute, your lordship, and there is due to some ongoing dispute, one person could not appear. The petitioner number 2.
Who could not appear?
Petitioner number 2,
Two.
Two.
Why he could not appear?
owing to some family problem, your lordship.
Mr. Barua, you have received a case diary.
No, my lord, search is submitted lordship.
Sarsit.
Yes, my lord.
Sarsit number?
My search number 432 of the 2023, dated 30/12/2023, under section 376, 212, 506, 34, read with section 4 of POCSO Act, against all the accused persons shown as absconders in the search.
Under section 376.
212, 506, 34 IPC, read with section 4 of POCSO. 432 of 2023.
Section 4 POCSO. Against
My lord, against all the accused persons and showing them as absconder in the search.
all the accused persons.
All the accused persons.
However, your lordship, the interim was granted on basis of the FI, your lordship, and except the first, except the first person, the other persons were granted interim on basis of 212 and 506 IPC, your lordship.
Pardon?
Except the first person in the FIR, all the accused were granted interim on basis of 212 and 506 IPC. Wide order dated 22/12/2023, your lordship. Interim.
So Sarsit was submitted against accused.
All the accused persons lordship showing them as absconder.
However, your lordship, except one petitioner, all the other petitioners appear within the due course, your lordship. There has been some negligence
Hmm?
on part of the police authorities, your lordship. They appeared in the due course.
So you go and appear before the court below. We'll fix it that.
Till then, your lordship,
Till then, we will extend the interim protection. So main accused is one Abdul Malik.
Abdul Malik. Your lordship, this court already rejected his anticipatory bail.
Already?
Already rejected his anticipatory bail. His AB was already rejected. Abdul Malik.
Heard, Mr. Your good name?
A and Iqbal.
A.
A and Iqbal.
Learned counsel for the applicant, and also heard Mr. Arjay Vora, learned additional PP for the state respondent. Apprehending arrest in connection with Rupohi Hat PS case number 414 of 2023 under section 376 212 506 34 IPC. It is section 4 of the POCSO Act. This application under section 438 CRPC is preferred by 5 applicants, namely Abdul Hasim, Nur Jamal, Joydul Islam, Moidul Islam, and Asad. Who have been apprehending arrest in connection with Rupohi Hat PS case number 414 of 2023 under section 376 to questioning. It's to be noted here that above noted case has been registered on the basis of one FIR lodged by one Nur Mohammed on. When it was filed, the FIR
4/10/2023.
4/10/2023. The sense of allegation made in the FIR dated so and so is that on 25/8/2023 at about 4 p.m. in the afternoon, accused Abdul Malik called the daughter of the informant, Shrimati X, which is second name withheld, aged 17 years. And while his daughter was sweeping in the house of the accused, then he committed sexual intercourse upon her. Thereafter, the victim has reported the matter to him, and then he reported the matter to the family members of Abdul Malik, namely Abdul Hasim, Nur Islam, Zoidul Islam, Moidul Islam, and Asad, and they have threatened him and also harassed him not to lodge any case against Abdul Malik. The learned counsel for the applicant, Mr. Iqbal, submits that this court, by order dated 22/12/2023, was pleased to grant the privilege of interim period bail, and pursuant to the said order, except applicant number 2, Nur Islam, the other applicants have already appeared before the IO, and due to some family problem, the applicant number 2 could not appear before the IO, and that the rest of the applicants have been cooperating with the investigating agency, and therefore it is contended to make the interim order dated 22/12/2023 obsolete in the same terms and conditions. On the other hand, Mr. Borua, learned additional PP, submits that in the meantime, he has not received the case diary, but he has received the instruction from the IU concerned that investigation of the case has already been completed, who is culminated in submission of charge sheet being charge sheet number 432 of 2023 dated 30/12/2023 under section 376 212 506 34 IPC. Read with section 4 of the POCSO Act against all the applicant. Having heard the submission of learned advocates of both sides, and also considering the fact that the investigation has already been completed and charge sheet has been submitted against the present applicant, this court is inclined to dispose of this application by directing the applicants to appear before the learned court below and to apply for regular bail. And in the event of filing such an application, the learned court below shall consider the same in accordance with law. Till then, interim order dated 22/12/2023 stands extended. Date
25th April,
25th April.
oblige your lordship. Item 16,
CDB, no, not required.
16,
Why this IA?
item
Mr. Iqbal, why this IA was filed?
Your lordship, this I was filed for Nur Jamal, for
Acha,
extension of Indian, your lordship,
acha, okay.
and since it not appeared.
Well, 16th case that is not received.
item 16,
None appears for the applicant on call or SSL leaves the matter on
23rd.
23rd. In the event of subsequent non-appearance, appropriate orders shall follow.
17,
Made his lordship. Lordship, in terms of the interim bail granted by this honorable lordship, the petitioner has appeared before the IO and has cooperated with the investigation procedure, lordship.
Well,
Yes.
two accused persons were arrested, lordship, and they have implicated this accused person and also other witnesses, lordship. They have
No,
implicated-
he has already been granted the interim bail.
person granted, he is
Uh,
appeared,
PS, yes,
statement recorded,
recorded.
recorded.
So what is the stage of investigation?
Although that is pending in respect to the other accused person, lordship. Other accused persons are yet to be arrested.
Arrested. Heard Mr.
B Pal.
Learned counsel for the applicant and also heard Mr. Ajay Barua, learned additional PP for the state respondent. Apprehending arrest in connection with Karimganj PS case number 988 of 2023. Under section 120B, 143, 333, 332, 186, 353, 307, 294, 392 IPC. Read with section 13/14 of the Assam Game and Betting Act. Game and Betting, or it is Gambling or Betting Act?
Gambling and betting, it should be game and betting angle.
Game and Betting Act.
Should be game. and
Assam Game and Betting Act. Read with section 53(1)(a) of the Assam Excise Act. This application under section 438 services preferred by applicant. Bibhu Pal alias Bibhas Pal for grant of PSP. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one
SIP.
Hmm?
Dulu Boro.
essay
SIP Sri Dulu Boro.
where it is mentioned.
Your lordship at paragraph 3, page 3 of the petition, lordship.
No, in the FIR where it is mentioned.
Your lordship, page 17.
Page
17.
on the basis of one FIR lodged by SI Dulu Boro of Karimganj PS on 38/12/2023. The essence of allegation made in the FIR dated so and so is that acting on a tip of the informant along with other police staff conducted raid at Bagargul Bazar under under Kaligans. On 29/12/2023, and while they raced in the shop of Joyhari Das, they have found him playing dice and board. And seeing the police party, they started running and managed to escape. And in the meantime, they have apprehended one Omiyo Pal and Rajesh Pal from the shop of Joyhari Das and recovered 40 numbers of McDowell Ram, 20 numbers of McDonald #1 Ram, one black colored TVS Raider motorcycle with key, and one red color Hero Pleasure scooty, and mobile phones, and seized the same in presence of witnesses. And while they were conducting raid in the said shop, then 20 to 30 people who assembled there unlawfully with criminal conspiracy assaulted the police personnel present there, and tried to kill the driver of the vehicle by strangling his neck. And they also rebuked them with abusive words. And stolen the mobile phone of the driver of their vehicle. The learned counsel for the applicant submits that this court by order dated 2/2/2024 was placed for grant the privilege of interim period bail to the applicant and person to the said order he had appeared before the IO and cooperating with the investigating agency. And therefore, it is contended that the interim order dated 2/2/2024 may be made absolute in the same terms and conditions. Whereas Mr. Rajay Barua, learned additional PP, has produced the case before this court and confirmed that the applicant had appeared before the IO and cooperating with the investigating agency. However, Mr. Barua has opposed the petition on the ground that the IO has collected sufficient incriminating material against the present applicant. But having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Barua, learned additional PP. It appears that the applicant was granted the privilege of period bail by order dated 2/2/2024, and he had appeared before the IO and cooperating with the investigating agency. Though the IO has collected some incriminating materials during investigation against the present applicant, yet, in view of the cooperation being extended by him to the investigating agency, his custodial interrogation seems to be not warranted here in this case, and therefore, the interim order dated 2/2/2024 is hereby made absolute in the same terms and conditions. Case diary be returned.
Item number 18.
None appears for the applicant on call is the matter after vacation.
Item 19.
Your Lordship, 438 application, Your Lordship. I am on interim. I have appeared and recorded my statement, Your Lordship.
Borua, you received the case ID?
My lord, two kettles were stolen also when it was recovered from the house of my lord one
Accused number 1.
Islamuddin lordship. He was arrested and he has implicated these three persons lordship.
Hmm.
One is Pramadud Islam,
Mhm.
another is Saddam Ali alias Hussein lordship. This is the present petitioner, and another is my lord Umar Odi lordship. The cow has been recovered and it is seized lordship. Cow.
Hmm.
Now, allegation is that my lord they have my lord stolen the cow and it was my lord tied in the house of my lord Islamuddin, my lord,
Hmm.
and it was recovered from the house of Islamuddin.
Okay. Heard Ms. F. Hussain, learned counsel for the applicant, and also heard Mr. R.J. Borua, learned additional PP for the state respondent. This parent number 2 and 3 of order dated 28/2/2024. Ms. Hussain, learned counsel for the applicant, submits that by order dated 28/2/2024, this court was pleased to grant the privilege of interim period bail to the applicant and person to the said order. He had appeared before the IO and cooperating with the investigating agency. Therefore, Ms. Hussain contended that the interim order dated 28/2/2024 may be made absolute in the same terms and condition. Whereas Mr. R.J. Borua, learned additional PP, has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the applicant, and therefore Mr. Borua has opposed the petition. However, Mr. Borua submits that the applicant had appeared before the IO and his statement is recorded. Para, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also perused the case area with the assistance of Mr. Borua, learned additional PP. Case area indicates that the IO has collected some incriminating materials against the applicant, but it also appears that material part of the investigation is almost over. The stolen cow has already been How many cows?
Two cows.
Two numbers.
And the stolen 2 numbers of cow have already been recovered and seized by police. And further, it appears that the applicant has been cooperating with the investigating agency. And he appeared before the IO person to order dated 20/2/2024 and cooperating with the investigating agency. Further, in that view of the matter, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore, the interim order dated 20/2/2024 is hereby made absolute in the same terms and conditions. Case be reiterated.
Oblige, Your Lordship.
Hearing method. Under which section?
My lord, I have not talked to the my lord. I have said my lord.
If it is a 365, then mandatory period of detention is 60 days.
My lord, my lord.
Yes.
Right.
Hmm.
Tomorrow, my lord.
Hmm?
That I may fix it tomorrow, my lord.
Tomorrow.
Tomorrow, my lord.
Lordship, tomorrow I am not present.
Pardon?
Lordship, for it, I will go to native village
Tomorrow.
Lordship, it will be held on 11, tomorrow is 10. And today is 57 days, Lordship.
That's all right. But, city has to be seen. No,
My lord,
he will
my lord.
produce the city tomorrow.
Tomorrow, my lord.
You ask someone to remain present on your behalf.
Any other person?
If we say that, if we find that the investigation is already completed, then definitely we may consider your
My
prayer.
lord, my lord.
Mr. B. Sharma, learned additional PP. Price for granting him 1 day time to produce the case before this court. Here is accordingly allowed. This is the matter tomorrow.
My lord.
Timing item 32.
Sorry, my lord, I was not there on time. With all respect, my lord, NDPS, my lord. 439, my lord, 152 days, commercial quantity, my lord.
So how do you satisfy the requirement of 37?
Yes, my lord, it will be possibly, it will be difficult, my lord, on my part.
How many days you are behind the bar?
152 days, my lord. 152.
Yes,
Date of arrest is November 21, 23.
November 20.
21. Oh, sorry, my lord, 10/11/23, my lord.
152 days.
Yes. So if it is difficult on your part to satisfy the requirement of section 37, then how can I help you?
Exactly, my lord, the embargo does not go away, my lord. I agree, my lord.
10.
Anyway, diary, I do not know, my lord. Diary is before your lordships. Diary, I said, my lord.
Diary.
Yes, so Bora, whether it was recovered from his
Yes, my lord,
position.
it is recovered from his possession, lordship. 55 numbers of cough syrup bottle and my lord 4 grams of heroin.
How many cough syrups? Bottle?
25 bottles. Lord.
25 bottles. And heroin?
4 grams. Lord.
4 gram is a small quantity.
Small quantity.
And 25 bottle of cough syrup is
Commercial.
commercial. How?
But 10 grams is becomes commercial. That's right. The 10 bottles.
Whether there's a FSL report is available.
But
Also.
that FSL, it is pending for only FSL report.
So, how can we say that the amount is commercial quantity?
Oh my God, because 100 ml each bottle also.
Maybe the
So-
quantity may be less in each bottle also.
No, that FSL will reveal also. That's it.
Then let him produce the FSL report.
Mine.
Better.
My lord. As your lordship,
My lord, we'll send back the case diary. Also. So today is my lord 152 days. That we'll send back the case diary. We'll call it after 2 weeks. Also.
Mr. RJ Barua, learned additional PP, submits that he has received the case diary, but the FSL report is not available in the case diary. Accordingly, it is provided that Mr. Barua shall produce the FSL report before this court on 19
My lord,
or
not 19, my lord.
19,
23. Lord.
23 without fail.
highly obliged, my lord. Obliged.
We'll retain the case.
Ah, yes, you can.
Obliged, my lord. Obliged. Obliged.
Item number 20.
The petitioner is on interim and he has. He appeared before.
You have appeared before the IO.
Yes, Lord.
When?
After getting the interim lordship, 22 interim order was there. I do not know exactly the date, but he has appeared before the IO.
No, is it not your duty to apprise the court the actual date on which you appeared before the IO? Yes, Barua, city receipt.
Case diary not received to them.
Not received. Okay, Mr. Arjay Barua, learned additional PP, submits that he has not received the case diary. Accordingly, it is provided that Mr. Barua shall produce the case diary before this court on
26/4.
short date
Similar item is
Sorted,
fixed
madam.
on 19 lordship,
19.
19.
Then 19. Lord.
19.
AB number 421.
Till then, interim order dated 22
number?
to 24 shall continue. Mr. Besbarua, learned counsel for the. Are you Besbarua?
No lordship. S.J. Sharma, I am.
S.J. Sharma. Learned counsel for the applicant submits that. Similar bail application arising out of Howley PS case number 8 of 2024 has already been fixed on
19.
19, being AB number
421
421
of 2020.
of 2024. Resis shall take this application along with the AB number 421 of 2024.
21.
Lordship, second bail application, the Lordship has already rejected it. Page 20 is a rejection order. On last occasion, Lordship, my only ground of filing this second bail application was 41A has not been issued till date to me. And your Lordship has posed a question to me that whether anticipatory bail can be granted since 41A not issued to the petitioner. Lordship, in my restful submission, I have not found a single judgment that since 41A is not issued, anticipatory bail could be granted.
Since 6,
Since anticipatory 41A not issued, for that reason, anticipatory bail has to be granted. I have not found any straight judgment on that ground.
yes.
CD received, my lord, sufficient incremental evidence.
So after rejection of this first application on 12/1/2024, is there any change of circumstance in your favor?
Lordship, there is no change of circumstances. In fact, on merit, your Lordship has already decided the first bail application and rejected it.
Then how can this court help you?
Lordship, my only prayer is that 41A not issued till date. So on last occasion, Lordship, I placed a order passed by this coordinate bench of this honorable court. AB number 1662. This was disposed by the order dated 7/8/2020. This was also a second bail application, successive bail application, which was registered under POCSO Act. Therein also, Lordship, 41A was not issued. So this honorable court directed the concerned investigating officer to comply with the directions, guidelines contained in Anish Kumar, Lordship.
But it was during the COVID period, my lord. It was in order reflected. It was COVID.
No, maybe you have to comply the direction and guidelines issued in the case of Ernest Kumar
Lordship.
and also in the case of Satinder until in all conditions.
My lord. But in the at present, I have no my lord judgment. But it was there that 2 weeks time, within 2 weeks time, my lord, notice
41
may be
has to
issued.
be, yes.
Notice to be issued. But even if not paid, my lord, it was not given, my lord. It will have to explain the delay. Why not given the notice, my lord?
The superintendent of police has to record the reasons why within 2 weeks of institution of the case, 41A was not issued by the investigating officer. That has to be there. And that has to be sent to the concerned magistrate of the jurisdictional magistrate. That why 41A was not issued and why you have not arrested. Your Lordship may kindly see whether any effort was made by the concerned investigating officer regarding the issuance of 41A. If the 41A was issued and I did not receive it and I am responding, there is absolutely no case at all, Lordship. And if it is not issued and
Okay, heard Mr. Arbora, learned counsel for the applicant, and Mr. B. Sharma, learned additional PP for the state respondent. Apprehending arrest in connection with Dolgao PS case number 411 of 2023 under section 379 IPC. This application under section 438 services prepared by applicant Rafiq Ali alias Rafiq Ali for grant of arrest bail. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Abidur Rahman. Lance Nayak of Doipam Police Outpost on 25/12/2023. The essence of allegation made in the FIR dated so and so is that the informant along with his staff were attending patrolling duty on 24/12/2023 and at about 2:30 AM they have intercepted one Baleno vehicle in front of the house of one Manohar Ali without registration number, and after checking the same they have recovered 2 numbers of cattle from the same. Mr. Borda, learned counsel for the applicant, submits that this is the second pre-arrest bail application prepared by the applicant, and the first one being AV number 107 of 2024 was dismissed by this court by order dated 12/1/2024, and that Mr. Bora also submits that there is no change of circumstance after rejection of the first bail application, first period's bail application on 12/1/2024 in favor of the applicant. And the only ground of filing this second period's bail application is that the IO has not furnished any notice to him under section 41A CRPC. Then therefore, Mr. Bora has contended to allow this petition. Whereas Mr. D. Sharma, learned additional PP, has produced the case diary before this court and submits that sufficient materials are there in the case diary to justify the custodial interrogation of the applicant, and as no change of circumstance shown to have occurred in favor of the applicant, this petition is not maintainable, and therefore Mr. Sharma has contended to dismiss the petition. So, is there any attempt made by the IO to furnish copy of 41A notice in the case? Having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record, and also peruse the case diary. It appears that indisputably, this is the second bail period's bail application preferred by the applicant, and the first one being AB number 107 of 2024 was dismissed by this court by order dated 12/1/2024 after perusing the case diary. And admittedly, there is no change of circumstance in favor of the petitioner, applicant, after rejection of the first application on 12/1/2024. It is well settled by catenary decision of Honorable Supreme Court that subsequent bail application is maintainable only when there is change of circumstance in favor of the applicant. Reference in this context may be made to a decision of Honorable Supreme Court in the case of A. Raja versus, keep it citation, I will give you later. Since no change of circumstance has been shown to have occurred in favor of the applicant, this court is of the considered opinion that this second period's bail application is not maintainable, and accordingly the same is dismissed. However, it is provided that the IO shall comply with the provision of section 41A CRPC before proceeding against the present applicant further. In view of the judgment of Honorable Supreme Court in the case of Ernest Kumar versus State of Bihar, reported in so-and-so, and also in the case of Satindra Kumar Antil versus CBI. In terms of above, this AB is disposed of. Case very returned.
My lord.
Applied lordship.
23.
My lord, I am actually not connected with the case. In nowhere in FIR or anywhere my name is not is there. But local police station, Tarabari police station, inquired in my house regarding 2497/2022 of dispute police case. I am a contractor. I am doing contractor in Kokrajhar and in Guwahati and some water resource in department in Bohoi also. I apprehend arrest, and if I am arrested, a social stigma will be there, and it will hamper my contractual work also. That's why I am coming from this anticipatory bill. Already CD has, I think.
Did he receive?
We have received the case diary, my lord.
Is there any material against him?
Well, material lordship directly, I have not been able to find out any material in his name, my lord. But only question is that, my lord, he's in bail application also, lordship, his only apprehension that Lucas police has, my lord, searched him in connection with dispute police station case number.
Local police has inquired. At that time, I was not in.
Let him complete.
Because, my lord, if it is connected to dispute police station case, lordship, it is within the state of Assam, lordship. Dispute police can directly go, my lord, and my lord, inquiry him. Anyway, lordship, my lord, what I submit, lordship, since I have not found anything, my lord, till now, lordship. And this case there is up to, lordship, February 2023, lordship, 24, lordship. So let him appear, lordship, if anything found, lordship, it is from the case diary, my lord. As I have not been able to, my lord.
No, it is all right, but if there is no material, why should we keep the matter pending?
It is
My
true,
lord,
but-
main accused is also released from judicial custody, already released.
The question is that, lordship, if
Yeah, was it
after, my
not?
lord, February, lordship, if something is found by the IO, lordship. against him,
Definitely, if there is any material against him during investigation, if you can collect any material against him, you can file search it against him. He will face the trial.
That's my.
Hmm.
then I leave it to lordship.
Heard Mr. D. Goswami, learned counsel for the applicant, and Mr. B. Sorm, and Mr. R.J. Barua, learned additional PP for the state respondent. Apprehending arrest in connection with dispute PS case number 2497 of 2022 under section 420, 468, 471 IPC. This application under section 438 surface is preferred by applicant Majnur Ali for grant of PS bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Who lost the FIR?
Punyot Prabha Hazarika.
On the basis of one FIR lost by one Punya Devi Narayan,
Yes. Well, yes, Narayan Hazarika actually.
alias Punya Prabha Hazarika, on when it was filed
24/11/22.
on 24/11/2022. The essence of allegation made in the FIR dated so and so is that she is the owner of a plot of land measuring 1 bigha covered by Doug number 401,
So we said.
comma,
What
400.
by 945? Patta number 233.
No, in the FIR,
Oh, in the FIR. Okay, anyway, that number makes sense. No problem.
we'll go by the FIR.
Okay.
Covered by Doug number 401, stroke, comma, 400 within bracket old, stroke 945 new, under KP number 155 within bracket old, stroke 233 new. of Bliss Darwandha under Beltola Mauza, which she has purchased by executing 4 registered sale deeds and paying land revenue regularly. And one Deposit Nath of Gandhi Basti executed one power of attorney being serial number 5646 and deed number 1139 dated 5/3/2022. Of Sri Nogen Gogoi and herself. And along with one Ajoy Kumar Sharma and Pankaj Biswas. Prepared the said force registered instrument of general power of attorney with a view to grave her land. Mr. Goswami, learned counsel for the applicant, submits that by profession the applicant is a contractor and is no way involved with the offense alleged in the FIR, but he is being searched by police in connection with this case, and that he is ready to cooperate with the investigating agency, and therefore Mr. Goswami contented to allow this petition. On the other hand, Mr. R.J. Barua, learned additional PP, has produced the case diary before this court and fairly submits that materials so far collected by the IO in the case diary are inadequate to show the complicity of the applicant with the offense alleged in the FIR. However, Mr. Barua submits that the applicant may be directed to appear before the IO and the case diary may be directed to be sent back to the IO concerned for updating the same and to produce the same before this court later on. But having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record. And also the case diary with the assistance of Mr. Barua, learned additional PP. The case diary fails to indicate anything against the present applicant. To show any legally prosecutable culpability. Is nowhere in the FIR and also in the materials collected so far, there is any reference to the present applicant. Under the aforementioned facts and circumstances, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this application. Accordingly, it is provided that in the event of arrest of the applicant in connection with this for PS case number so and so under section so and so, he shall be released on entering on a pre-arrest bail. On his executing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority. Above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of Chief Judicial Magistrate Kamrupe without prior permission. In terms of this evidence discourse of case that is returned.
24.
Oblige. Oblige, sir. Highly oblige.
Four 38 application lordship. In this case, lordship, the present petitioner is the owner of the track lordship. And lordship, as per the contents of the forward FIR lordship, one this early lordship once a time lordship, and he was my engaged driver. And subsequently, he is driving the another vehicle lordship. But he was arrested in connection with this case. But police went to my house lordship for searching me. So there is the apprehension lordship. Otherwise, lordship, my vehicle is not seized, but he was my driver once a time. That is the lordship. Police visited my house.
Yes, anything, Mr. Borga?
But we have received the case diary, Lordship, and driver said, Lordship, that owner of the cow, Lordship, is from Rupo Hill, Lordship. My lord, who purchased the cattle, Lordship, and my lord, the owner of the cattle and the driver, Lordship, they together, my lord, in my lord, connivance, my lord, they carried the my lord, cattle without any documents, Lordship. And when police apprehended, they could not produce any documents.
No, is there any material against the present?
Again, my lord, he is the owner of the vehicle, Lordship, and my lord, police is my lord. Lordship, police is, since he is the owner of the vehicle, that is why my lord, police is asked him to my lord for interrogation, Lordship.
Hmm.
But directly, Lordship, driver statement, he has not implicated the owner. Lordship.
Hmm. Okay, heard Mr. F. Hawk, learned counsel for the applicant, and Mr. R.J. Borwa, learned additional PP for the state respondent. Apprehending arrest in connection with Bosisto PS case number 842 of 2023 under section 379 IPC, read with section 11(1)(d) of the Prevention of Cruelty to Animals Act, read with section 13(1)(16) of the Assam Cattle Preservation Act. This application under section 438 service is preferred by applicant Mustafa Ahmed for grant of PS bail. It's to be noted here that above noted case has been registered on the basis of one FIR lodged by one ASI Bipul Sando Deka of Zurabat Police Outpost on 28/12/2023. The essence of allegation made in the FIR dated so and so is that the informant on 27/12/2023 at about 10 p.m. No, at about 4:30 a.m. on the intervening night of 27/12/2023. No, not intervening night. On the intervening night of 28/12/2023, while he was attending patrolling duty at Zurabat Tiniali and checking the vehicles, then he has intercepted one vehicle bearing registration number NL01K 7143 and found 26 numbers of live cattle being carried in the same without any document and in an atrocious manner. And the driver of the vehicle failed to produce any valid document and accordingly arrested him. Accordingly, he has arrested the driver, namely Idris Ali. Mr. Hawk, learned counsel for the applicant, submits that the applicant is no way involved with the offense alleged in the FIR, and the only materials available against him is that the driver of the vehicle bearing registration number NL01K 7143 was his driver. And you were not the owner of the vehicle.
No. This vehicle is
And that he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. RJ Bora learned additional PP also. By producing the case that before this court fairly submits that the present applicant has not been implicated by the materials, no, by the witnesses examined by the IO and also by the driver. So, Mr. Borua, is there any material to show that he is the registered owner of that vehicle?
sorry, I could not have produced at the time filing, Lordship. I have to.
Who is the owner?
Mustafa.
Driver is not implicated in this. Driver is
No,
implicated.
Mustafa is the present applicant.
Lordship.
He is the owner of the vehicle.
That is different, Lordship, vehicle Lordship, and he is the different vehicle owner Lordship. But yeah,
No, I am asking you whether the vehicle which is seized in connection with this case is the present applicant is the registered owner or not? No. Okay, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on record and also prepared the case diary with the assistance of Mr. Barua, learned additional PT. In view of the materials collected so far in the case diary, and also in view of the submission of learned advocates of both sides, a custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Bosista Pierce case number so under section so he shall be released on interim Pierce bail on his executing a bond of rupees 50,000 with one security of like amount with the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of CJM. Kamrup M with the prior permission.
Item 25 for orders.
Lordship, this application has been filed for a small modification matter. What happened? My lord, his father's actual name is Nurul Islam. In the bail order, it has been mentioned Nur Islam. And my lord, in the forwarding report, police had mentioned my lord as Abul Ali. And due to this mismatch, my lord, he was not released by the learned CJM. Now I am praying, my lord may say that his father's name may be read as Nurul Islam alias Abul Ali, my lord. This is my prayer. Page 3, para 3, my lord. Actually.
Therefore, সোমাই আছে।
allow for an local.
So in the order where it is mentioned?
My lord, in the post title, Aminur Islam alias Aminul Ali.
Yes, son of Nurul Islam.
Nur Islam.
Yes.
But his father's actual name is Nurul Islam. In my petition, it is Nurul Islam.
Hmm.
But in the order, it is Nur Islam. That is one.
Ah.
And another is in the, my lord, forwarding report, police has mentioned as Abul Ali. My lord,
Wording report we cannot correct.
uh,
We cannot correct.
but this mismatch, my lord, the
This
learned
we
agent
can,
denied.
this we can do
Yes, my lord.
in our order.
One line observation is, my lord, made that
What
due to-
observation?
due to, my lord, this mismatch, my lord, his bail may not be denied, my lord.
No, we cannot, that is the
But-
discretion of the court
But
below.
Abul Ali is not his father.
We don't know.
If required, Lordship, the trial court will mother call report from the concerned officer.
Yes, IO.
I-
Trial court can call for a report from the IO, who is the father of the accused.
Actual father.
Yes.
But Nurul Islam, I have mentioned is Nurul Islam in
Okay, we will do it.
the, my lord,
Heard, Mr. Your good name?
M. Ali.
Learned counsel for the applicant and Mr. Borua, learned additional PP for the state respondent. This interlocutory application is preferred by applicant Aminur Islam alias Aminul Ali for correction stroke modification of the order dated 15/3/2024 passed in BA number 756 of 2024. It is to be noted here that by the impugn order dated, by order dated 15/3/2024, this court was placed to grant the privilege of bail to the present applicant. Mr. What was your name?
M. Ali.
Mr. M. Ali, learned counsel for the applicant, submits that in the order dated 15/3/2024, the name of the applicant has been mentioned as, the name of the father of the applicant has been mentioned as, in the bail order dated so and so, the name of the applicant has been shown as the son of one Nur Islam, resident of village
Obdohar.
Vagdahar under Dhuburi PS. But the name of his, but the said name ought to have been, but the applicant ought to have been mentioned as son of Nurul Islam. And on account of this, and also on account of mentioning the name of father of the applicant in the forwarding report as Abul Ali, the court below has not accepted the bail bond furnished by the present applicant, and therefore it is contended to make necessary correction of the name of the father of the applicant. But having heard the submission of learned advocates of both the parties and also considering the materials, also considering the record, this court is inclined to dispose of this interlocutory application by directing that henceforth the name of the father in the order dated 15/3/2024 shall be read as Nurul Islam, resident of village Vagdahar, under Dhubri PS. I have also carefully gone through the forwarding report dated 18/2/2024, where the name of the father of the applicant has been reflected as Abu Lali. And as such, there is mismatch of the name of the father in the forwarding report and also in the bail order dated 15/3/2024. In respect of the same, the learned court below can call for a report from the IU concerned as to who is the actual father of the applicant of the present applicant, and thereafter, on the basis of the report, take necessary action in this regard.
Number 26 for hearing.
My lord, learned trial court may call for a report, my lord.
Question.
Oblige.
Item 26 for hearing.
None appears for the appellant on call. Recessal is the matter after vacation.
So part third matter, so. Part third
As
matter,
part third.
date fixed. Second May.